Hello and welcome to Patent Agent Exam Preparation Lectures. And today, first we'll try to understand what is a patent and what is the patentability criteria. And after that, in next coming lectures, we'll study the whole process in detail. So let me share my screen. So yeah, to begin with, I think because we are giving the patent agent examination and the most important element of this exam to understand what is a patent, that's why we'll be able to discuss patents with our clients. So because this exam is focused on the Patents Act, we'll study the sections. We'll also study application of these sections, but learning about these sections is absolutely necessary for the purpose of exam. That's why instead of going into logical definitions and application based definitions, we'll study the definitions which are mentioned in the act. So let's begin with what is a patent. So under the Patent Act, section 21M defines patent, and according to it, patent means a patent for any invention granted under this act. So I think this is my own way of learning about patents from the act. Like if you want to start reading Patent Act, you should know the term patent. So in the term patent, which is defined under section 21M, which is the most important keyword. It is invention. Then you can press Control F and search for what is an invention. And you will find a definition. Invention means a new product or a process involving an inventive step and capable of industrial application. So what are most important parts of this definition? The first important part is the word new. Second important part is the word product or a process. The third important part is the word inventive step. And the fourth important part is the word capable of industrial application. And from here, we get to know about the patentability criteria. What can be patented? An invention. What is an invention? An invention is a new product or a process involving an inventive step and capable of industrial application. So let's see how do we learn about these terms. So the word new implies novelty. Product or a process implies subject matter eligibility. Inventive step implies inventive step. And in many other jurisdiction, it is called non-obviousness. Because we are giving the patent agent exam, we need to stick to the term inventive step. We don't have to go into the term non-obviousness. And the fourth term is capable of industrial application, which indicates the term utility. So what are four elements? Novelty, subject matter eligibility, inventive step, and utility. Now let's see where the word novelty is defined in that act and where are other terms defined. So the term novelty is defined in the section 21L, which discloses the definition of the word new invention. So from this definition of invention means a new, we come to the definition of new invention, and that's how we read about novelty. From the from the word product or a process, we come to the exception where in section 3 and 4 it is mentioned what cannot be patentable. So a product or a process is patentable, that is from this definition, and what cannot be patentable is defined in section 3 and 4. Then comes the term inventive step, which is defined in section 21JA. So simply if you try to search for these terms in the act itself, you will find it. Just that you'll have, for the purpose of exam, you'll have to remember in which section what is defined and how it is defined. How it is defined, we'll come to it in next slides. And then we have the term capable of industrial application, which indicates utility. And where is capable of industrial application defined? It is defined in section 21AC. of the Patent Act. Now, apart from this, I have used the word anticipation, and the and important sections related to the word anticipation is section 13 and section 29 to 33. You can include section 34 also in this only because it is also included in section of anticipation. But yeah, more or less it is from section 13 and 29 to 33 where the word actually anticipation is used, or the term actually anticipation is used. So what is the difference between novelty and anticipation? Because our act itself, it uses the term new and it uses the word anticipation. So you need to remember that something which is new is not anticipated, and something which is anticipated cannot be new. Anticipated means we are able to foresee that thing, or that thing already exists. So something which is anticipated cannot be new. Something which is new cannot be anticipated. So these two words are opposite of each other's, and our Patent Act use both of these words, the word new and the word anticipation. So let's come to novelty. So, according to the Act, novelty is indicated in Section 21L, which defines new inventions. So, what are the important elements of these inventions? First, this definition. First, we'll read the definition, and then we'll understand the important parts. Any invention or technology which has not been anticipated by publication in any document, or has not been used in any country or elsewhere in the world before the date of filing of the patent application with complete specification, that is, subject matter has not fallen in public domain, or that it does not form part of the state of the art. So what does this mean? This simply means if you are filing something today, it should not be disclosed in any document. Anticipated by publication means it should not be published anywhere, not even in previous patent applications or journals or textbooks or articles or blogs anywhere. It should not be disclosed anywhere, or has not been used in the country. Or has not been used in the country means your product should not be used anywhere. So when will your product be considered as new? It will only be considered as new if it is not disclosed in any publication, which includes articles, blogs, previous patent application, journals, etc., or it has not been used. That is, nobody knows how to use that product. And you should emphasis on the word elsewhere in the world. So if you are filing a patent application in India, you cannot do a novelty search in India only. Like you cannot, if I want to file a patent on this pen, I will do a novelty search where I'll see whether the same pen exists anywhere in the world or it does not exist anywhere in the world. It should not be limited to a particular country, because this section particularly includes the term in the country or elsewhere in the world. So it is a global search that we need to do. And by when it should not be published, till I file my patent application. So if I file my patent application on 1st April 2023, all the things which have been disclosed or used prior to this date, I need to check that, and according to that only I can take a decision and file my patent application. So it is an important definition and an important concept for the purpose of answering your written questions as well, that what is novelty? Novelty means your product should be new. And how will your product be new? It simply means it should not be disclosed anywhere in the world, or it should not be used anywhere in the world. So if it is not been disclosed and not been used, that means the subject matter has not fallen yet in the public domain and it does not form part of the state of the art. So this is just the explanation part. That is, the subject matter has not fallen in the public domain, or that it does not form part of the state of the art. So this is about novelty in the light of our Patents Act. And apart from these, Section 13 and 29 to 34, which are related to anticipation, are also important, that we'll probably discuss in our next lecture. The second term, which is important and which is one of the requirement to get a patent, is the word inventive step. So what is inventive step? For that, we need to study section 21JA, which means inventive step in the Patent Act is defined as feature of an invention which involves technical advance as compared to existing knowledge or having economic significance or both. And that makes the invention not obvious to persons skilled in the art. So whenever you are filing for a patent, you should know that in your patent application or in your claim or in your invention, there should be technical advancement or economic significance or both. So more emphasis is given on technical advancement. So if the level of technical advancement is low, the economic significance should be very high to get a patent. So, or if the value of technical advancement could be very high, and then economic significance would not matter. But in order to tell whether I can get a patent on this technology or not, I will check inventive step. So if my patent application involves a technical advancement and has economic significance or both, my invention would not be obvious to the person skilled in the art. And then only I am satisfying the requirement of inventive step. Now a question may come to your mind that how is my invention not obvious to the person skilled in the art? So whenever we go to the examination phase, most of the time examiner will cite a few uh, prior arts and tell us your invention is obvious in the light of these documents. And to that reply, we'll form our arguments. And with those arguments, we'll say, because our invention has a technical advancement over the prior arts which you have cited, or, our invention has economic significance over the inventions what you have cited, or there is technical advancement and economic significance both in our invention in the light of whatever inventions you have cited, then only my invention is not obvious to the person skilled in the art and I am qualifying the inventive step. So whenever I need to get a patent, I need to qualify for novelty, inventive step, subject matter eligibility, and utility. So let's now come to utility. Utility simply means capable of industrial application. So if my invention is capable of being made or used in an industry, it is capable of industrial application, which is defined under section 21AC. So in this section, the definition of utility is there. How I can say whether I can get a patent on this or not, or my invention is useful or not. I need to establish that my invention is capable of being made or used in an industry. And if it is capable, utility is satisfied. Till now, I haven't seen any patent application where the utility was not satisfied. Obviously, if any article is of no use, you will not file a patent for it. So this is also, but this is a requirement that we need to fulfill. Now, what we read the term product or a process in the definition of patent, in the definition of invention. So invention means a new product or a process involving an inventive step and capable of industrial application. So what all things are included in the word product or a process is what is defined. What all things can be patented, either a product or a process. So what all things fall into this domain? Any process or a method, for example, new way of manufacturing a concrete, or any machine which has some moving parts, or a manufactured article like microphone, pen, glass, candle, anything which is a manufactured article, or composition. Composition means which has some chemical composition. Example, pharmaceutical drugs or adhesives. So these are some examples of compositions. So these are the things which can be patented. But our Patent Act specifically defines what cannot be patented. So it is defined under Section 3 and Section 4 what are the things which cannot be patented. And it is very, very important to understand these and to learn. Like for the purpose of examination, you should know what is mentioned in 3A, 3B, 3C, 3D, 3E, 3F, 3J, 3K, 3L, 3M, 3N, 3O, and 3P. So because in objectives, questions may come like why this is not patentable, under which section of the Patent Act this is not patentable, or a question can come whether uh, uh, whether I can a new form of planting a tree is patentable or not. So from those to answer those type of question, you need to know where it is mentioned that what cannot be patented. So you need to remember these terms, and it is important for the purpose of longer questions as well, because most of the times questions come with the scenario, and to answer that scenario we need to mention under which section this cannot be patented or why this can be patented. So for that purpose you need to answer with the sections mentioned in section 3 and section 4. So let's try to understand these sections uh, so that you are able to answer the questions as well. So section 3A says anything which is contrary to natural laws or is frivolous cannot be patented. So these laws are not legal laws. These laws are scientific laws. For example, you are making a machine which is giving you an efficiency of more than 100%. That is scientifically not possible. So if it is scientifically not possible, we'll term that invention as contrary to natural laws or frivolous, and we cannot get a patent on it. Then section 3B says anything which is immoral or contrary to public order. So for example, I'm manufacturing an explosive for the purpose of hampering the public around me. I cannot get a patent on this because that is immoral or contrary to public order. Then we have section 3C, which uses the word mere discovery is not patentable. Now, what is the difference between an invention and a discovery is an invention is something which a person has made, but discovery is something which is existing, but people did not know about it. For example, gravity. If Newton explored gravity today, Newton can get a Nobel Prize. He can get anything, but he cannot get a patent. Why? Because gravity is existing and he just identified an existing thing. But if he manufactured something which uses gravity for the purpose of XYZ, then that is a manufacturing process. And because that is created by a person, it can be patented. So we need to know the distinction between mere discovery and invention. Inventions can be patented, mere discovery cannot be patented. Then we have section 3D, which says new form, new use, new property of a known substance or new use of a known process. So in this section, basically, to give you an example, if we have a drug, for example, paracetamol, and for now, paracetamol is used for curing fever. Now, I have started using paracetamol to cure pain as a pain relief medicine. So it is a new use of an existing product. So if it is a new use of an existing product, I cannot get a patent on it. Then we have section 3E, which is mere admixture. So in section 3E, if I make salt and sugar solution together, salt is also existing, sugar is also existing. I cannot get a patent on it. But in these sections, you need to remember that if I'm getting a surprising result because of mixing of two elements, for example, if I am using paracetamol with a drug XYZ, both are existing in nature, but I did not know that these two drugs can be used to cure cancer. Or it is giving me a surprising effect that it can be used to cure cancer. In that situation, I can get a patent. Why? Because I will be able to see that, show that I am bringing out enhanced efficacy, and in that scenario, it can be patented. So it is an exception. Normally, under section 3E, it is not patentable, but we have an exception. And I would suggest going through these sections in detail and see the applications of these sections as well. Some of the examples I am giving, if you remember these examples, you'll be able to answer the questions very well. But a fair reading of the act is important. So next we have mere arrangement or rearrangement. Like we had mere admixtures for pharmaceuticals, similarly we have mere arrangement and rearrangement for mechanical inventions. For example, in this pen, if I remove this cap from here and put it at the back, it would be mere arrangement or rearrangement of things. If in a mechanical machine I am taking one part and putting it at a different position, it would be mere arrangement or rearrangement. So mere arrangement or rearrangement of existing things cannot be patentable. Then we have method of agriculture or horticulture. Now here you need to be very careful because the act says method of agriculture or horticulture. It does not say system of agriculture or horticulture, devices of agriculture or horticulture. It just says method of agriculture or horticulture. So under this, for for the purpose of this act, only methods are not patentable, but devices or systems can be patentable. So if I am manufacturing a tool that is used for agriculture or horticulture, I can get a patent on it. But if I am having a method of planting seeds in a different manner, so that is a method of doing agriculture, that cannot be patented. Similarly, we have section 3I, which says process of treatment. So again, this section says process of treatment. So I cannot protect whether the drug has to be eaten orally or drug has to be injected, but I can protect the surgical tools that a doctor may require to do some diagnostic. So I can protect diagnostic kits. I can protect surgical instruments because devices can be patented, but processes of treatment cannot be patented. Next, we have section 3J, which says parts of animals or plants cannot be patented, but the exception is microorganisms. Microorganisms, if they are invented by human beings, can be patented, but parts of animals or plants cannot be patented. Next, we have section 3K, which is one of the interesting sections, which says computer program per se, mathematical method, business method, and algorithm cannot be patented. So here we have four elements: computer program per se, mathematical method, business method, and algorithm. So basically, three elements are easy to understand, like mathematical method. If there is some mathematic steps involved, that we cannot patent. If I am making a business method, a method to earn money, but it does not have any technology in it, I cannot patent it. If it is a merely algorithm, maybe calculations, maybe if this if else statements or any algorithm of the sorts, we cannot get a patent. But The important distinction here is to understand computer program per se, which uses the word per se, and according to our law, per se is not defined anywhere in the act. So what does computer program per se means? So in many decisions, the examiners and the controllers have come to the conclusion, if computer program is doing some general purpose computer functioning, it cannot be patented. But if we are doing something extra than mere computer functioning, that can be patented. I know this is tricky because we don't know what is general computer functioning and which cannot be considered as general computer functioning. So if we have practical applications of a computer program, for example, a computer program is used to manage alarm system of a very big industrial organization, probably that can be patented because we are showing use of a computer program. But if it is a general purpose computer program, then we might not get a patent on it. Next, we have section 3L, which says literary, musical, dramatic, and artistic work cannot be patented. So basically, these are subject matters of copyright. We can get a copyright on this, we cannot get a patent on this. Then we have section 3M, which says mere scheme or rule cannot be patented. So if I'm making a scheme or rule or a new method of playing game, I cannot get a patent on it because playing game is also considered as a scheme or rules for something. Then 3N is presentation of information. How I am presenting information, that I cannot get a patent on. For example, if I'm delivering this lecture in audio video manner, I can also give this lecture in written manner. So presentation of information cannot be patented. Then we have topography of integrated circuits. So basically for integrated circuits, which is topography of integrated circuits, we have a different act, and because of that act, it is not considered under patent. So topography of integrated circuits cannot be protected under patents, but it can be protected in a different act. Then we have section 3P, which is traditional knowledge. So anything which is traditionally existing in our knowledge. For example, there are a lot of preparations which have been traditionally existing. And how to know about whether that can be considered as traditional knowledge or not, we have traditional knowledge digital library, which is TKDL. So if anything is present in traditional knowledge digital library, I cannot get a patent on it. Why? Because it is an already existing knowledge. So it would not be considered as new. It would not be considered as involving an inventive step, and would also be considered as something which is existing in our traditional knowledge. So because of that reasons, we cannot get a patent on this. And then we have section 4, which says invention related to atomic energy cannot be patented because government is the one who is doing all the research in that area, and they don't want people to do research and get patents in this area for the purpose of public security. Therefore, inventions related to atomic energy cannot be patented. So basically, from this section, questions can come in the form of objective questions, which would be specific to the sections, and question can come in the subjective sections where you'll be given a situation and you need to tell whether something is patentable or not. So for that, I would suggest make 4 headings: novelty, inventive step, utility, and subject matter eligibility. In each of these headings, you can tell whether the invention is novel or not, whether the invention has inventive step or not, whether the invention is subject matter eligible or it is barred under any of the sections 3 or 4, or whether it is patentable. So if you, and then you can come to utility and say whether this invention has utility or not. And if you, after answering novelty, inventive step, subject matter eligibility, and utility, then in conclusion, you can write, because I'm satisfying all these four criteria, I can get a patent. Because I'm not satisfying subject matter eligibility, I cannot get a patent. So it will depend on that situation. So I think that's all for this lecture. Just focus on these key element of what is a patent and how we analyze the patentability criteria. Remember these sections, and then I will see you in the next lecture. Thank you.